Hi, Jack Meligan here, your Medicare problem solver for the Plaintiff's MSA and Lien solution. Today's video, the 3 Medicare problems every trial attorney must solve for their clients. The first Medicare problem you must resolve is the Medicare Conditional Payments issue. This is the past medical that Medicare wants to be repaid at the time of settlement or just after. Not only is there a very real threat of double damages for missing this with Medicare or a Medicare Advantage plan, as the trial lawyers at Paris Blank discovered, not dealing with the Medicare conditional payments in a timely manner can cause a huge time delay in getting defendants to pay over an agreed upon settlement amount. Most defendants are demanding to see a copy of Medicare's final conditional payments demand letter before letting go of the settlement check. But the process with Medicare can take 90 to 120 days, in some cases even longer. So starting well in advance of a possible settlement date is imperative if you want to avoid disappointing your client, your bookkeeper, or your banker. The second Medicare problem trial lawyers must solve for your client involves the question of MSAs and future Medicare liability. While absolutely not required by law, that misses the bigger point. The bigger point is that the law making Medicare secondary to all forms of insurance has been in the books since 1980, almost 37 years, and ignorance of the law is no defense. When Medicare is notified or otherwise discovers that your client has had a settlement that includes compensation for future medical, Medicare is precluded from paying. When your client gets a letter from Medicare denying payment and they have no money left from their settlement so that they can't pay, who are they going to call? Advising your client on the reasons for and against creating a voluntary, minimalized MSA account and with or without professional administration is imperative if you want to avoid having an uncomfortable phone call from your client sometime down the road. The third Medicare problem trial lawyers must solve for their Medicare card-carrying plaintiffs is the Section 111 settlement report that defendants are legally required to submit to Medicare on the date of settlement. This report has 196 data points. Now, not all of them are filled in on every report or any one report. But one data point that is critically important to your client is the complete list of all the ICD-9 or 10 codes that identify the treatments for your client's injuries or conditions that were the subject of their settlement. This information goes into your client's common working file at Medicare, and Medicare is supposed to match up these ICD-9 and 10 codes with future billings and then deny payment for bills that reference the same ICD-9 and 10 codes. There have already been numerous instances where defendants have misreported or even negligently reported pre-existing conditions or even misreported some other plaintiff's conditions to Medicare. When this happens, your client can be erroneously denied payment from Medicare for those services, which can really cause a lot of potential problems, maybe even life-threatening, and it takes a trip to see an ALJ to straighten out the mess. So adding language to your settlement agreement and release that prevents or strictly limits the potential damage that a defendant's negligent Section 111 report to Medicare CMS can cause is imperative if you don't want to have to fix one of these messes. Do you want or need help with any or all of these? The Plaintiff's MSA and Lien solution knows the secrets and has the answers. See us on the web or give us a call. Protect your clients and save them money as well as future hassles with Medicare. We will take these issues off of your desk along with the hassle, worry, and expense of compliance so you can rediscover the joy of why you got into plaintiff's trial law to begin with. This has been Jack Meligan, your Medicare problem solver for the Plaintiff's MSA and Lien solution.